Hello everyone, today we're going to be answering the question, can I sue my employer for negligence? Yeah, of course you can, but if that's part of your workers' compensation claim, then the answer is no. Or sure, you can try to sue, but then it's going to get dismissed right away, and you're not going to find an attorney who's going to be taking that on if it's part of a workers' compensation claim. I answered a very similar question in a recent video, which I'll put right up here, and that question was, can I sue if my employer, if I have an accepted workers' compensation claim? Now, the thing about negligence specifically is that it is sort of kind of assumed. Negligence just means that there's an accident, right? And it could be negligence on the part of an injured worker, or it could be negligence on the part of the employer. And California, we have a no-fault state. It's a no-fault state when it comes to injuries on the job. So whether you were not behaving according to certain safety protocols and got yourself injured, or whether the employer was negligent, it doesn't matter. You're going to be covered under workers' compensation, and you can't, generally speaking, you cannot sue under, you cannot sue outside of the workers' compensation system. So let me give you an example. If you are a trucker, and chances are you work for a trucking outfit where they have a 3-point rule, which means that when you're getting in and out of your cab, you have to have 3 parts of your body touching something, and so for example 2 of your hands are holding on to handles or handrails, and you have 1 foot on a sort of stepladder or something like that, and then your free foot can then be not touching something and can swing yourself into the cab or out of the cab, something like that. Well, if you were to only have, let's say, your left hand and your left foot touching, and you were getting in and out of your cab that way, and let's say you slipped because you didn't have that 3rd point of contact, well, it's really your fault, right? You messed up and you were not behaving according to protocol. But California is a no-fault state, so it's not like you will not be entitled to benefits because you failed to act according to your safety policy. Similarly, if you have let's use the same example of a trucking company, and let's say you have you're getting in and out of the cab, and let's say there's a hinge that comes undone, and because of that you slip and fall. Well, you could say, well, that's negligence on the part of the employer. Well, that's true, but you can't. That's assumed as part of the workers' compensation system, so there's no additional lawsuit that you can file against the employer for that. That's going to be part of your workers' compensation claim. Having said that, if a hinge were to actually come undone on the door, you might have a separate civil lawsuit against somebody other than the employer. You might be able to sue, for example, the manufacturer of the hinge or the door of the truck or whatever. But as far as your employer is concerned, you're not going to be able to sue them under a negligence theory in civil court in addition to your workers' compensation claim. Let's see, I wanted to say also that there's a difference between negligence and recklessness, right? So negligence just means it's an accident, sorry it happened, it shouldn't have happened. Recklessness is where an employer or an employee, where you know of a dangerous anything, factor, environment, something that can cause danger in a work environment, and you behave despite the knowledge that this factor in existence would likely cause harm. So for instance, if there was a giant gaping hole, let's say in a construction site, an unexpected gaping hole that was going to send you 20 feet down into a ditch, and if somebody had told the employer about that, like, hey, there's this giant gaping hole, there are no cones around it, we're out of cones, what do we do? And if the employer said, forget it, who cares? That would likely be reckless, because it would be clear that type of a hole would in fact cause bodily harm if somebody were to fall in it, and that it would be likely that somebody would fall in it if there were no warning signs, no cones, no nothing around it. So, difference between negligence and recklessness. If your employer acted recklessly, though, you still don't sue in civil court. Instead, within the workers' compensation, I guess, board, within that authority, they have jurisdiction. It's the Workers' Compensation Appeals Board. You file what's called a serious and willful claim. There's a statute of limitations on that, so you have to make sure that you file like as soon as possible. You just don't want to waste time when it comes to that. But the standard for recklessness and the standard for negligence are really, really different, and it's very easy for people to say, well, you know, I want to say that they were acting recklessly. It's a very specific standard. So just if you're confused about that, or if you want to talk to somebody about that, my contact information is below. I'm happy to answer any questions that you might have as to whether an employer might have been behaving negligently versus recklessly, and I can answer your questions when it comes to that. All right, everyone, so please leave any comments or questions down below, and I'll be sure to get back to you as soon as I possibly can. And if you have a question that you want me to answer in an upcoming video, let me know, and I will do that as soon as I can. Until next time, I wish you the fullest life possible. Take care.